Good evening, everyone. I welcome each one of you to our AOR Aspirants Academy. This is our 9th lecture series on the topic how to draft public interest litigation. It is our everyday prayer before starting the session. We generally recite the preamble of the Constitution. The reason is we always celebrate or praise our Mother India by reciting Janagana Mana. But who is our father? One who protects Mother India, that is our legendary father, dynamic father, that is the Constitution of India. The Constitution of India, which prescribes the territories for India, and it prescribes who are the citizens of this country. It describes what are the fundamental rights, fundamental duties, how our entire nation functions through legislative, executive, and the judiciary. Therefore, there may be many provisions of the Constitution, but the object, the soul of the Constitution is embedded in the preamble of the Constitution. Therefore, I request each one of you to recite the preamble along with me, therefore to praise our father, legendary father, that is the Constitution of India. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much. Today, the topic for discussion is how to draft public interest litigation filed under Article 32 of the Constitution of India. That is the topic. I would like to touch upon this topic under 4 headings. Firstly, the historical background, what we have seen so far, number 1. Number 2, the evolution of PIL. Number 3, misuse of PIL. Number 4, what is the practice and procedure in Supreme Court with respect to PIL. Number 5, how to draft. Because collecting all these materials put together, we can draft a writ petition with reference to public interest litigation is concerned. So based on these headings, I would be dealing or approaching this topic for today. Firstly, the historical background. First and foremost is Article 32 of the Constitution of India gives us a right to approach the Honorable Supreme Court. Article 32 is the remedial measure. When there is a violation of any of the fundamental rights guaranteed under Part 3 of the Constitution. Right to equality, right to freedom of speech and expression, right to life and personal liberty, right against untouchability, abolition of titles, right to free education, right to freedom of religion. So there are many fundamental rights guaranteed by the Constitution, under more particularly by Part 3 of the Constitution. If that being the position, if somebody violates those fundamental rights, if somebody is aggrieved, where will he approach? The approach is under Article 32 of the Constitution of India. That is the reason Dr. B.R. Ambedkar in his Constituent Assembly he has said, I could not refer to any other article other than the one, that is Article 32. In the absence of that article, all the fundamental rights becomes meaningless. Therefore, according to Dr. B.R. Ambedkar, Article 32 is the very heart and the very soul of the Constitution. And Article 32 clause 1 says, the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part, that is part 3, guaranteed. So when there is such violation, we have to establish before the Honorable Supreme Court that this is my fundamental right and that right is violated, therefore I am aggrieved. Therefore, to maintain a public interest litigation, or before that, to maintain a writ petition, one has to establish his locus standi. What is locus? Locus means place. Stand means where to stand in a place. How do you maintain your petition? So you have to establish your fundamental right, and out of that fundamental right, your right is violated, therefore you are aggrieved, therefore you are approaching the Honorable Supreme Court. But the doctrine of locus standi has got diluted. Why it is got diluted? Reason is, when there is underprivileged, when there is poor, illiterate, neglected children, bonded laborers, death in prison or in jail, how do they approach and have access to the highest court of the land? Therefore, the answer found by the honorable judges of the Supreme Court is, let us dilute the doctrine of locus standi. Therefore, public spirited person or any organization like Bandhuva Mukti Morcha, where they have fought for the bonded laborers, so any spirited person with bona fide, they can maintain a petition, therefore that will protect the public interest at large. That is the reason why the doctrine of locus standi was diluted, in order to protect the public at large. Because our preamble itself says it is a social justice. A person, those who are socially deprived, politically deprived, economically deprived, how do they have access to the highest court? Only through public interest litigation. And the Honorable Supreme Court has come out with by saying even letters written to the Honorable Judges or to the Honorable Supreme Court can be treated as a letter petition, can be treated as a PIL. The reason is, the Honorable Supreme Court gives its reason in its wisdom. It says, we cannot expect public spirited person to spend his money from his pocket and then engage a lawyer. He cannot do all the photocopies, or we cannot expect him to spend so much money. Therefore, public spirited person, if they write a letter, we will treat it as a petition and we will entertain it. The question is, under Article 32 clause 1, by appropriate proceedings. What is appropriate proceedings? Whether it has to be filed as prescribed under the Supreme Court rules, that synopsis, list of dates and events, brief facts, supported with annexures, grounds, and then prayer, followed by affidavit. So that is the requirement as per law. But the Honorable Supreme Court has held, the public spirited person or even the person who writes a letter, we will not confine ourselves to this appropriate proceedings. That means the form. We are concerned with the purpose. The purpose is to enforce the fundamental rights guaranteed under Part 3. So the purpose is very important. Form is immaterial. Therefore, letter can be treated as petitions, writ petitions. Dear friends, you have gathered here. The purpose is to become successful AOR in the coming sessions. So that is the purpose. Immaterial, whether you come from which commutation, that is immaterial. The purpose is, if you are here, you are keenly listening to it, what is the takeaway, what is your learning, that is most important. So the Honorable Supreme Court has said the purpose is important, the form is immaterial. So therefore they have diluted. So on the last session we had discussed about the Supreme Court has come out with certain guidelines with respect to the PIL is concerned, that they have got 10 parameters or 10 areas under which letters can be treated as a petitions. And they have also come out by saying there are 5 areas where it cannot be treated as a letter petitions. For example, service matters. For example, if there is a landlord tenant issues, that cannot be filed as a public interest litigation. So therefore, we have seen how the doctrine of locus standi is diluted by the Honorable Supreme Court, and how they have come out with certain guidelines that what would be falling under the parameters of letter can be treated as PIL, what cannot be treated as PIL. Apart from that, how was the evolution of PIL? When a seed was sown, that is PIL seed was sown by 2 honorable judges, we must remember them, Honorable Justice Krishna Iyer and Honorable Justice P.N. Bhagwati. The most important aspect is what they have said by interpreting Article 32 is Article 32 by appropriate proceedings. Don't read it in isolation. Don't interpret or don't read Article 32 in isolation. You have to read Article 32 in light of Preamble of the Constitution, fundamental rights, directive principles of state policy. Collectively, you must read Article 32. In like how Maneka Gandhi case, before Maneka Gandhi, they said Article 14 has to be read separately, 19 is separate, it is a watertight compartment. But after Maneka Gandhi, there is a golden triangle by saying that Article 14, 19 and 21 should be interpreted together, and they are all like a joint family. You cannot exclude one article and then you cannot interpret one article. To have a meaningful interpretation, purposeful interpretation, you have to read it together holistically. So this is what we have seen so far. The second is evolution of PIL. Evolution of PIL is how the branches or how the PIL has taken different avatars in order to protect the public interest. Firstly, we have discussed about Sunil Batra case, Sunil Batra 2, wherein the PIL was entertained in order to protect the prisoner's rights. Thereafter, yet another avatar is to protect the bonded laborers through Bandhwa Mukti Morcha. Then Vishaka versus State of Rajasthan, one of the avatars of PIL to protect the women from sexual harassment at workplace. Then how to recognize transgender as third gender, that is National Legal Services Authority case. And you have seen how PIL has taken avatar to protect the environmental issues, Vellore Citizenship Forum and MC Mehta case, where the doctrine of sustainable development, polluter pay principle, principle of precautionary measures, doctrine of absolute liability. So everything was discussed. Now today what we are going to discuss is how to prevent the misuse of PIL. Because once the PIL started entertained by our Honorable Supreme Court, when the doors of the justice is open for everyone, they started misusing it. So public interest litigation PIL has evolved as private interest litigation, publicity interest litigation, paisa income litigation, political interest litigation. So therefore the Honorable Supreme Court has laid down certain parameters. In one such case, that is Ashok Pandey, I would be referring now, a very beautiful judgment written by our honorable judges explaining about what is PIL, what is the scope of PIL, and how a court can entertain PIL with caution, and how it is being misused. Everything is dealt, entire PIL is dealt in this particular judgment. So I would be reading certain relevant provisions of that judgment. Therefore, you can have a holistic view about PIL. This is a case. The name of the case is Ashok Kumar Pandey. Ashok Kumar Pandey versus State of West Bengal. I repeat, dear friends, Ashok Kumar Pandey versus State of West Bengal. It is reported in 2004, Volume 3 Supreme Court Cases, page number 349. It is reported in 2004, Volume 3 Supreme Court Cases, page number 349. What is the issue is all about? Let me tell you in brief, then I will take you to the relevant provisions. In Ashok Kumar Pandey, he files a writ petition, public interest litigation, before the Honorable Supreme Court of India under Article 32. What is his grievance? He says there is one prisoner called Dhananjay Chatterjee in West Bengal prison. He was already convicted for death sentence by trial court, confirmed by Honorable High Court of Calcutta, even confirmed by the Honorable Supreme Court. So trial court, High Court and the Honorable Supreme Court has confirmed his death sentence. He preferred mercy petition before the governor, that was also turned down. Again he preferred mercy petition before the President of India, that was also rejected. Now he is remediless. Now Ashok Kumar Pandey, he was sitting at his home watching a news channel in which there was a news telecasted about this prisoner, that there is a delay in execution of his death sentence. He immediately watched that news, he filed a petition and he appeared in person before the Honorable Supreme Court. The Honorable Supreme Court put him a very important question. What is your locus? How are you related with Mr. Chatterjee? How can you maintain this petition? He said, I am a public spirited person and there is a delay in execution of his death sentence. Therefore, the death sentence has to be converted into a life sentence because of inordinate delay. That is what his response was. And he relied upon many cases like Sunil Batra and other SP Gupta case, that any public spirited person can maintain a PIL. So that was his submissions before the Honorable Supreme Court. So the Honorable Supreme Court had occasion to record what is the importance of PIL and how it is being misused and what happened to this judgment, whether was it allowed or dismissed with heavy cost. That is suspense. Let me read that. This one judgment, according to me, in my personal opinion, just running to only 9 pages. If you read this, you will understand the importance and evolution of PIL. It is beautifully written by Honorable Justice Arijit Pasayad. The facts goes like this, dear friends. The petition under Article 32 of the Constitution of India has been filed purportedly in public interest. What is this prayer? The prayer in the writ petition is to the effect that the death sentence imposed on one Dhananjay Chatterjee, alias Dana, hereinafter referred to as the accused, by the Sessions Court, Alipur, West Bengal, affirmed by the Calcutta High Court and this court, that is the Honorable Supreme Court, needs to be converted to a life sentence because there has been no execution of the death sentence for a long time. Reliance was placed on the Constitution bench decision of this court in Triveni-Ben versus State of Gujarat. He says there is a delay in execution of death warrant, that itself a sufficient ground to reduce from death sentence to life sentence. That was his prayer under Article 32 before the Honorable Supreme Court. Para number 2. According to the petitioner, Ashok Kumar Pandey, he appears in 14 person and he says he saw a news item on a TV channel wherein it was shown that the authorities were unaware of the non-execution of the death sentence, and therefore the condemned prisoner, the accused, had suffered a great degree of mental torture, and that itself is a ground for conversion of his death sentence to a life sentence on the basis of the ratio in Triveni-Ben case. It needs to be noted here, this is very important dear friends, it needs to be noted here that prayer for conversion of death sentence to life sentence has already been turned down by the Governor of West Bengal and the President of India in February 1994 and June 1994 respectively, as stated in the petition. So, 3 courts imposed death sentence, confirmed mercy petitions were rejected by the Governor of the West Bengal and the President of India. When the matter was placed for admission, now the matter, he files a petition and now matter is coming up before the Honorable Supreme Court for admission. When the matter was placed for admission, we asked, that is the Honorable Supreme Court has asked the petitioner who appeared in person as to what was his locus standi and how a petition under Article 32 is maintainable on such nature of information by which he claims to have come to know of it. His answer was that as a public spirited citizen of the country, he has a locus to present the petition, and when the matter involved life and liberty of a citizen, this court should not stand on technicalities and should give effect to the ratio in Triveni-Ben case. There has been violation of Article 21 of the Constitution, and the prolonged delay in execution of sentence is violative of Article 21 so far as the accused is concerned. So, he files this petition. When the Honorable Supreme Court asked him, how do you maintain this petition, what is your locus, he says, I am a public spirited person and it is a violation of Article 21 and 14. Therefore, this Honorable Supreme Court should not go into the technicalities. What is my locus? Please proceed with the substantial justice. This was his submission as a party in person. He placed a reliance on different judgments, that is given in para 3. Para number 4. When there is a material to show that a petition styled as a public interest litigation is nothing but camouflage to foster personal disputes, the said petition is to be thrown out. When you style that petition as a PIL and it does not has any substance, when it is out of personal vendetta you file it, then such petition has to be thrown out. Before we grapple with the issue involved in the present case, we feel it necessary to consider the issue regarding public interest aspect. Before going to this issue, as a Honorable Supreme Court wanted to go into what is the aspect of public interest in a broader line. Public interest litigation, which has now come to occupy an important field in the administration of law. It should not be publicity interest litigation or private interest litigation or politics interest litigation or the latest trend, paisa income litigation. If not properly regulated and abuse averted, it also becomes a tool in unscrupulous hands to release vendetta and wreak vengeance as well. There must be a real and genuine public interest involved in the litigation, not merely an adventure of a knight errant and poke one's nose into for a probe. It cannot also be invoked by a person or a body of persons to further his or their personal causes. Now they are saying under what circumstances PIL cannot be entertained. There must be a real and genuine public interest litigation involved in the litigation and not merely an adventure of a knight errant or poke one's nose into for a probe. It cannot also be invoked by a person or body of persons to further his or their personal causes or satisfy his or their personal grudge and enmity. Courts of justice should not be allowed to be polluted by unscrupulous litigants by resorting to the extraordinary jurisdiction. A person acting bona fide and having sufficient interest in the proceeding of public interest litigation will alone have a locus standi and can approach the court to wipe out violation of fundamental rights and genuine infraction of statutory provisions, but not for personal gain or private profit or political motive or any oblique considerations. So they have, in this paragraph, they have simply said public interest must be genuine. You should not come with certain motives. Further, these aspects were highlighted by this court in Janadal cases and Ghazi versus Central Bureau of Investigation. A writ petitioner, this is very important dear friends, a writ petitioner who comes to the court for relief in public interest must come not only with clean hands like any other writ petitioner, but also with clean heart, clean mind and clean objective. So this is what they prescribe about. You must not only approach the court with clean hands, but also clean heart, clean mind, and your objective must also be clean. Now the Honorable Supreme Court has discussed about what is public interest litigation as how it is defined under Black's Law Dictionary. And then in para 7, the Honorable Supreme Court discusses about scope of public interest. And para 11, this is the consequence. When a PIL is motivated or private interest, what are the consequences that follows? Para number 11. It is depressing to note that on account of such trumpery proceedings initiated before the courts, innumerable days are wasted, which time otherwise could have been spent for the disposal of cases of genuine litigants. Though we spare no efforts in fostering and developing the laudable concept of PIL and extending our long arm of sympathy to the poor, the ignorant, the oppressed and the needy whose fundamental rights are infringed and violated and whose grievances go unnoticed, unrepresented and unheard. Yet we cannot avoid but express our opinion that while genuine litigants with legitimate grievances relating to civil matters involving properties worth hundreds of millions of rupees and criminal cases in which persons sentenced to death and facing the gallows under untold agony, persons sentenced to life imprisonment and kept in incarceration for long years, persons suffering from undue delay in service matters, government or private, persons awaiting the disposal of cases wherein huge amounts of public revenue or unauthorized collection of tax amounts are locked up, detenue expecting the release from the detention orders, etc., etc., are all standing in a long serpentine queue for years with a fond hope of getting into the courts and having their grievances redressed. The busybodies, meddlesome interlopers, wayfarers or officious interveners having absolutely no public interest except for personal gain or private profit, either for themselves or as a proxy of others or any other extraneous motivation, or for the glare of publicity break the queue, muffling their faces by wearing the mask of public interest litigation, and get into the courts by filing vexatious and frivolous petitions, and thus criminally waste the valuable time of courts, and as a result of which the queue standing outside the doors of the court never moves, which frequent situation create frustration in the minds of genuine litigants, and resultantly they lose faith in the administration of judicial system. So they have elaborately discussed, it is not something that you file PIL with some private interest, because there are people who is really fighting for their property, where they have earned their property out of their blood and sweat, hard earned money. So when that property is taken away, he files a petition before the court to hear his grievance. So unnecessarily this misuse of PIL takes valuable time of the court. Instead of spending court's time in vexatious PIL, they can spend time in genuine cases like whose fundamental right is violated, or who is in jail for many years, or a property worth of many crores. So likewise, there are many people standing in the queue. These people wearing a mask of public interest litigation, they come by saying, but filing a frivolous petitions, that is mere wastage of time. That should not happen. Therefore, the Honorable Supreme Court gives a cautious note by saying, whenever the petition is styled as a public interest litigation, the court must be aware what is the reason behind it. So they prescribe certain guidelines also. Now, how to prevent the misuse, that they are discussing it here. Public interest litigation is a weapon which has to be used with great care and some circumspection, and the judiciary has to be extremely careful. The judiciary has to be extremely careful to see that behind the beautiful veil of public interest and ugly private malice, vested interest or publicity seeking is not lurking. It is to be used as an effective weapon in the armory of law for delivering social justice to citizens. The attractive brand name of public interest litigation should not be used for suspicious products of mischief. It should be aimed at redressal of genuine public wrong or public injury, or not publicity oriented or founded on personal vendetta. As indicated above, court must be careful to see that a body of persons or a member of the public who approaches the court is acting bona fide or not for personal gain or private motive or political motivation or other oblique consideration. The court must not allow its process to be abused for oblique considerations. Some persons with vested interest indulge in the past time of meddling with judicial process, either by force of habit or from improper motives. Often they are actuated by a desire to win notoriety or cheap popularity. The petitions of such busybodies deserve to be thrown out by rejection at the threshold, and in appropriate cases with exemplary cost. The Honorable Supreme Court went to the extent of imposing 5 lakh cost also. Not in this case, in general practice, when it is vexatious. Now, para 14 is very important. The Honorable Supreme Court has laid down the conditions, guidelines. First, before entertaining the PIL, the Honorable Supreme Court has to satisfy itself that it is a real, genuine PIL. So, the court has to be satisfied about what? Number 1, A, the credentials of the applicant. Who is the applicant who is coming before us? Is he really a public spirited person? That they need to say the credentials of the applicant. B, the prima facie correctness or nature of information given by him. What is the information that he is providing to the court? Nature of information that has to be seen. C, the information being not vague and indefinite. It is not something like, it should not be a vague one. It should be substantiated by the documents effectively. The information should show gravity and seriousness involved. Court has to strike balance between two conflicting interests. Nobody should be allowed to indulge in wild and reckless allegations, besmirching the character of others, and avoidance of public mischief, and to avoid mischievous petitions seeking to assail for oblique motives and justifiable executive actions. In such case, the court cannot afford to be liberal. When a person is started playing with the Honorable Supreme Court by filing a vexatious petition, dear friends, the Honorable Supreme Court, any court, it is like a fire. Before a fire, we need to be very, very careful. If you touch it either ignorantly or wantedly, intentionally, your hands going to be burnt. So you cannot play with the court. Court is considered to be a temple of justice. When the legislative or the executive fail, the last resort left to the litigant is the court. So when a person comes with the court, he must approach the court with clean hands. So when he does not do that, his credentials are under suspicion. That means the court will not approach such a person liberally. In such cases, the court cannot afford to be a liberal. It has to be extremely careful to see that under the guise of redressing a public grievance, it does not encroach upon the sphere reserved by the Constitution to the executive and the legislature. The court has to act ruthlessly while dealing with impostors and busybodies or meddlesome interlopers impersonating as public spirited holy men. They pretend to act in the name of pro bono publico, though they have no interest of the public or even of their own to protect. So para 6, which talks about misuse of PIL, para 17, it talks about application of law to the present case. So they discuss all the public interest litigation cases. Ultimately, para 17, how do they apply the law that was already decided to the present case? So far we have seen from paragraph number 1 to 16, what is the credential of the petitioner approaching the court? What is his source of information by filing the petition? And the Honorable Supreme Court has seen, before going into the issue, they wanted to discuss about the object of what is public interest, why it is started, and why the doctrine of locus standi is diluted. After diluting, how the PIL is grown up by wiping the tears of the prisoners, bonded laborers, neglected children, and thereafter how it is being misused, and what is the duty of the Honorable Supreme Court before entertaining a petition. What are the questions to be asked about the credentials, source of information, and who is the applicant? Everything has to be seen. Now, after discussing broadly on these issues, the Honorable Supreme Court comes to the case Ashok Kumar Pandey. What is his locus? What is his credential to maintain writ petition? Para number 17 of the judgment. Coming to the facts of the case, it has not been shown as to how and in what manner the accused condemned prisoner is handicapped in not seeking the relief, if any, as available in law. First and foremost is their question is, why Mr. Dhananjay Chatterjee, if he is aggrieved, why he has not approached? Why he has not approached? How he is being handicapped from approaching the court? That is not established. So that is first lacuna in this case. The matter pertains to something which happened or not at Kolkata, and what the truth about the news was, or which or cause for the delay, even if it be, is not known or ascertained or even attempted to be ascertained by the petitioner before approaching this court. The second aspect is why there is a delay in execution of death sentence. He says there is an inordinate delay in execution. Why there is a delay? He is unable to explain, or even he never made an attempt to explain the delay. That is the second lacuna. To a pointed query, the petitioner submitted that the petitioner may not be aware of his rights, that except the news he heard, he could not say anything further. The respondent state may come and clarify the position. This petition cannot be entertained on such speculative foundations and premises and to make a roving inquiry. Maybe at times even on certain unconfirmed news, but depending upon the gravity or heinous nature of the crime alleged to be perpetrated, which would prove to be obnoxious, to be avowed public policy, morals and greater societal interest involved. Courts have ventured to intervene, but we are not satisfied that this could be one such case. For example, in Bandhu Mukti Morcha, a letter was written by an organization. Immediately, the honorable judges appointed the commission to check the genuineness and veracity of the letter. Advocate Commissioner went to the spot, inspected the premises, and they saw those bonded laborers were in inhuman conditions. They were not given proper environment, proper food, proper shelter. So they submitted the commission. Such being the position, the Honorable Supreme Court treated letter petitions as PIL. But in this case, the Honorable Supreme Court is not convinced with Ashok Kumar Pandey's submissions. Courts have ventured to intervene, but we are not satisfied that this could be one such case on the facts disclosed. It is reliably learnt that a petition with almost identical prayers was filed before the Calcutta High Court by relatives of the accused, and the same has recently been dismissed by the High Court. So Satish Kumar Pandey has filed a writ petition before this court, before the Honorable Supreme Court. Exactly similar petition was filed by one of the relatives of Dhananjay Chatterjee, who was in the prison. That was dismissed. So that is also a lacuna or loophole in this writ petition. After discussing this, para 18 to 32, they discuss different case laws on the ground how the petitions were misused by the litigants, frivolous litigants. Those cases I am not going into because of shortage of time. Let me directly go to the conclusion, which is given at para 33. Para 33 of the judgment. It was noted that Article 32, which finds a place in Part 3 of the Constitution, entitled Fundamental Rights, provides that the right to move this court for the enforcement of the rights conferred in that part is guaranteed. It empowers this court, that is Honorable Supreme Court, to issue directions, orders, writs for the enforcement of any of the fundamental rights. The petitioner did not seek to enforce any of his fundamental rights, nor did he complain that any of his fundamental rights were violated. He sought to enforce the fundamental rights of others. He did not say that his fundamental right is violated. He is establishing that fundamental right of Dhananjay Chatterjee was violated. He sought to enforce the fundamental rights of others, namely the two condemned convicts who themselves did not complain of their violation. Ordinarily, generally, the aggrieved party which is affected by an order has the right to seek redress by questioning the legality, validity or correctness of the order, unless such party is a minor. Exceptions are generally the aggrieved party approaches the court except when the party is a minor. This is very important. When a public interest litigation or a writ petition is maintainable other than the aggrieved person. if he is a minor or insane person or is suffering from any other disability which the law recognizes as sufficient to permit another person, that is next friend, to move the court on his behalf. Para number 34. Unless an aggrieved party is under some disability recognized by law, it would be unsafe and hazardous to allow any third party, be it a member of the bar, to question the decision against third parties. Even they have gone to the extent of saying even the member of the bar, that is the advocates, cannot maintain a petition for violation of the rights of others. Para 35. Neither under the provisions of the code nor under any other statute is a third party stranger permitted to question the correctness of the conviction and sentence. As I earlier said, what is the suspense? Whether was it allowed or dismissed with heavy cost? The answer you can find at para 36 of the judgment. Based on the above background, we do not think this to be a fit case which can be entertained, and that too under Article 32 of the Constitution, and is accordingly dismissed but without cost. So therefore, dear friends, the essence what we have studied from here is Satish Kumar Pandey could not able to explain properly how he is aggrieved or how Mr. Dhananjay Chatterjee is aggrieved. Number two, he says that he comes to know only through the news channel, and he did not ascertain what is the reason for the delay in execution of the warrant. And similar petitions which was filed before the Calcutta High Court was also dismissed. Therefore, while dealing with his case, the Honorable Supreme Court, by writing two-page judgment, they could have dismissed easily. But why so much pain, effort was taken by the honorable judges to bring down what is Black Law Dictionary has defined about PIL, how the PIL was evolved, relying upon many cases, how it is being misused, and how PIL can be entertained, and ultimately discussing all the judgments that was involved from para 18 till up to 32. They were discussing about all the case laws and coming to the conclusion. The reason is, I will tell you the reason why they have dealt so much in detail. To explain about PIL like this, we have to refer 10 judgments. Those 10 judgments, essence is given in one judgment. This is a credit, we can give it to the Honorable Justice Arijit Pasayed Justice, my Lord. He has taken so much pain to enlighten all of us. So if PIL comes in our AOR question, please try to answer this, and I hope that you will get good marks. Now after discussing this misuse, the topic for today is how to draft a petition. To draft a petition, we need to fulfill the criteria mentioned in the Supreme Court rules, because Article 32 provides us the remedial measure, and the Supreme Court Rules 2013, the Supreme Court has made rules for itself. But what is the source of power for the Honorable Supreme Court to frame Supreme Court Rules 2013? Who is the father and mother of Supreme Court Rules 2013? The answer is Article 145. Let me take you to the Article 145. Article 145 of the Constitution of India, which deals with rules of court, etc. Article 145 clause 1 reads like this: subject to the provisions of any law made by Parliament, the Supreme Court may from time to time, with the approval of the President, make rules for regulating generally the practice and procedure of the court, including number 1, A, rules as to the persons practicing before the court. This is very, very important, dear friends. Rules as to the persons practicing before the court. Who are all practicing before the Honorable Supreme Court? Advocates, senior advocates, advocate on record. So, regarding advocate on record examination, they prescribe everything false originates from Article 145 Clause 1A. B. Rules as to the procedure for hearing appeals and other matters pertaining to appeals, including the time within which appeals to the court are to be entertained. Which appeals to the court are to be entered. C. Rules as to the proceedings in court for the enforcement of any of the rights conferred by Part 3. Today's topic is how to draft PIL. The most important aspect is Clause C, Article 145, Clause 1C, which deals with rules as to the proceedings in the court for the enforcement of any of the rights conferred by Part 3. So, the Supreme Court derives its source of power from 145 Clause 1C to frame rules, that is Order 38. Order 38 of the Supreme Court rules deals with writ petitions, dear friends. I draw your attention to Order 38. Order 38 of the Supreme Court rules. What does it say? Order 38 of the Supreme Court rules 2013 deals with applications for enforcement of fundamental rights under Article 32 of the Constitution. It deals with habeas corpus, mandamus, certiorari and everything. But our focus today is on public interest litigation. Therefore, we must look into Order 38, Rule 12. Dear friends, this is very, very important, and most of the times this question appears in AOR examination. When you want to file PIL, what you are supposed to disclose to the court? Under which provisions of the Supreme Court rules that governs the PIL? The answer is Order 38, Rule 12. Subrule 1 says, please kindly make a keen attention, dear friends. Now we have come to the heart and soul of our topic. A public interest litigation may commence in any of the following manners. So what they are saying is, the Supreme Court rule says public interest litigation can be initiated only under 4 conditions. Firstly, as a suo motu petition in pursuance of the order of the Chief Justice or Judge of the court, the Honorable Supreme Court on its own motion can take cognizance, and by virtue of the orders passed by the Chief Justice or Judge of the court on suo motu petition, that they can do it. In Kolkata rape and murder case, it was a suo motu petition taken by the Honorable Supreme Court. That is one creation or one way of initiating PIL proceedings. Second way is in pursuance of an order of the Chief Justice or a judge nominated by the Chief Justice on a letter or representation. The second aspect is when a letter is written to the Honorable Supreme Court. Now it does not reach directly the judges to the hands of the judges. When you just write a letter to the Supreme Court, a letter petition, that goes to the PIL cell, Public Interest Litigation Cell. Public interest litigation scrutinize the papers and they place it before the judge of the Honorable Supreme Court, who is nominated by the Chief Justice of India. Only then matter is listed before the court. So this is the second way, that is letter treated as a public interest either by the Chief Justice or a nominated judge by the Chief Justice. This is the second way of initiating a public interest. What is the third way? C. By an order of the court to treat a petition as public interest litigation. So there will be an order of the court. For example, we file a writ petition, but that writ petition can be treated as a PIL if there is an order by the Supreme Court, because it involves many people, interest of many. Therefore, we will frame guidelines. So that petition will be treated as a public interest litigation. This is third way of initiating PIL. What is the fourth one? By presentation of a petition in the court. We file a public interest litigation itself. So hope it's clear, dear friends. There are four ways in which you can initiate public interest litigation. Firstly, suo motu petition by the judges, by the Chief Justice or the judge of the court, Supreme Court. Number two, a letter petition can be treated as a PIL by the Chief Justice or judge of the Supreme Court. Number three, any petition can be treated as a PIL by order of the court. Number four, the petition is itself styled as a public interest litigation. So these are the only four ways by which a writ petition of PIL is initiated as per these rules. Number 2, Order 38, Rule 12, Sub-Rule 2, which says in a petition filed under Clause D, that is public interest litigation has been filed, under which the petitioner is supposed to disclose certain material facts. What are those material facts? This is very, very important. When you file a petition, public interest litigation, you have to disclose who are you, what are you. So what is the requirements that we need to disclose is A, disclose his full name. For example, I file a PIL, so I need to disclose my name, my complete postal address, email address, phone number, proof regarding personal identification, occupation, annual income, PAN number, and national unique identity card number if any. So this a petition must contain all this. B, the facts constituting the cause of action. How this petition, what is the cause of action to maintain this petition? I need to explain to the court. Number C, the nature and extent of personal interest, if any, of the petitioners. If I have some personal interest in my public interest litigation, I must disclose to what extent my personal interest is there in the petition. D, the nature and extent of personal interest, if any, of the petitioners. C is the nature of injury caused or likely to be caused to the public. When this petition, why I am filing this petition is because the nature of injury might cause to the public at large. So I must establish the injury also. I must establish my personal interest in the petition also. E, details regarding any civil, criminal or revenue litigation involving the petitioner or any of the petitioners which has or could have a legal nexus with the issues involved in the public interest litigation. And F, so I need to establish that if I am the petitioner or I have 2 or 3 people as a petitioner, I need to establish that there is no civil suit pending nexus to the public interest litigation. So I am not seeking indirectly a relief from the apex court with respect to the pending cases before the civil court. That cannot be done. F, whether the concerned government authority was moved for relief sought in the petition, and if so, with what result. Generally, we should not come directly to the highest court of the land. Highest court of the land, that is apex court, pass a direction to the government consent department to execute whatever we require. So first question that they will ask us is, did you approach the consent department? Did you give a representation to them? If you have given the representation, what is the response? Whether there was no response or delayed response, what is the cause of action to come to us directly? So we need to establish that. So these are all the informations that we need to plead in the public interest litigation. Then file an affidavit stating that there is no personal gain, private motive or oblique reason in filing the public interest litigation. There is no publicity interest, private interest or political interest. I am filing genuinely for the interest of the public at large. That you must state by way of an affidavit. Why here affidavit, dear friends? This is very, very important. When you file an affidavit, before the court of law, it becomes a part of evidence. When tomorrow the Union of India establishes that he has given a false affidavit on oath, that means there can be a contempt action initiated against the petitioner who has given a false statement. There can be a perjury petition can be initiated because he has committed an offence under section 193 of old IPC, giving false evidence. So you cannot give false evidence before the court of law. So therefore, even in Rajneesh versus Neha, where affidavit of assets and liabilities is to be filed by the husband also as well as by the wife also to claim maintenance when wife claims the maintenance. When such affidavit is given falsely, then a contempt petition can be initiated. It amounts to commission of the offence under 193 of IPC, 199 and 209 of IPC. Therefore, perjury petition lies against them. Therefore, whenever we make a statement before the honorable any court, be it High Court, be it Supreme Court, be it any court, dear friends, you must approach the court with clean hands. Not only clean hands in respect of public interest is clean heart, clean mind and clean objectives. So you cannot play with the court because they will not leave you liberally. Now, Subrule 3 of Rule 12 says the court may impose exemplary cost on the petitioners if it finds that the petition was frivolous or instituted with oblique or malafide motive or lacks bona fide. Thereafter, the provisions contained in Order 15 relating to petitions generally shall, so far as may be applicable, apply to petitions under this order. So they are referring to Order 15 also. What is Order 15, dear friends? It generally, what are the pleadings? When you plead, it has to be in paragraph wise and it has to be numbered properly and it has to be supported with affidavit, and those general pleadings applies to our PIL also. So far what we have seen is the origin of PIL, avatar of PIL, misuse of PIL and how to draft we have collected from the Supreme Court rules. Now everything, all the materials before us, now how to draft it. Drafting is very, very important. In drafting, how it has to be, there is a Latin maxim, verba volant, scripta manent. What does it mean? Spoken words fly away, but written words remain. Tomorrow one may say that I will sell you my property orally, and if you go tomorrow, you have said give me your property, he will say when did I tell you? You only told me that you will give your property to me. They may change because nothing is written, right? Therefore, spoken words fly away, gone with the wind, but written words, that is why we require a sale deed. See, you have executed the sale deed, there is a sale consideration, attesting witnesses are there, therefore I am the owner of the property. That is how we establish. So in a PIL, in any drafting petitions, the client will come to you, he will explain you all the grievances, but you will filter it, in your wisdom you will filter it, whether is it a material facts, What will you state before the Honorable Supreme Court? So first and foremost is you should ask yourself, what is the prayer before the Supreme Court? When you want to travel somewhere, we will fix the destination. If you want to go to Chennai, I am going to Chennai on such and such date. Whether commutation by train or by flight, that is different. Destination is important. So likewise, the destination in the petition is the what is our prayer. Once prayer is fixed, you have to do two things. What are the facts and what are the grounds? The facts and grounds should reach you to the destination, that is your prayer. That is very important. So how to draft writ petition, public interest litigation? We all know CPC means Civil Procedure Code, right? But let me give that CPC in different form for drafting. C is clarity in your mind. It is easy to remember, dear friends. First, you should have clarity in your mind. What is the grievance of the petitioner, your client, and what you want the relief from the court? So there is a clarity. What is P? Plain and simple language. Don't make it complex. Make it brief. What is C? Remaining C? Concise form. Whatever you want to say in 2 paragraphs, say it in few sentences. So it should be, there should be clarity in your mind, plain and simple language. Another C is concise. For this, I would like to give 2 examples of Tirukural. What is the Tirukural? Unheard of for many. Tirukural is written by Saint Thiruvalluvar. Tirukural is a book written by Saint Thiruvalluvar. He touched upon the aspects, different aspects of life. He has written almost 1330 couplets under 133 chapters. Each chapter consists of 10 couplets. So 133 chapters into 10, 1330 couplets. He has dealt with many, but he never referred to any religion. He never referred to any God, but he has referred to only one, that is humanity. Human religion he has referred. In one of his chapters, that is chapter 34, he has dealt with 2 aspects. Uncertainty of life. The life is very important. How he discusses about the uncertainty of life in concise form. Whatever in Tirukural he says, the 4 words at the top and 3 words in the bottom. That's all, only 7 words. He completes the entire worldly knowledge in 7 words. I will explain you. In one Tirukural, I say it in Tamil and I will translate it in English also. நாளென ஒன்றுபோல் காட்டி உயிர் ஈர்க்கும் வாளது உணர்வாய் பெறின். What does it mean? He is asking ourselves this question. What is the time? What is the day? If somebody asks you what is the day, you will say today is Monday, tomorrow Tuesday, Wednesday, Thursday. But that is for ignorant people. For ignorant, it may be Monday today. But for wise person, he says, it is a sword cutting your life to death. It is every day a sword cutting your life. Sword which puts down your life. It is like every day we are moving towards our destination. D for destination, D for death. You are moving towards it. Please remember it. It may appear to be September. It may appear to be Monday. It may appear to be 23rd September. No. We are growing old. Black hairs are turning out to be grey hairs. So be careful. Do whatever you are, do it with virtues. That is what the Thiruvalluvar said. And yet another Tirukural, he says, he is asking ourselves this question. What is the relationship between the body and the soul? He beautifully explains, dear friends, and easy to understand even for an illiterate. He says, Kudambai குடம்பை தனித்து ஒளிய புல் பரந்தற்றே உடம்போடு உயிரிடை நட்பு. He says, he compares bird as a soul, nest as a body. The bird can fly at any point of time leaving the nest. Similarly, the soul can fly away like a bird leaving the nest like body. How beautifully explained in 7 words, explaining the entire life philosophy. Only thing is, we all know it, we remember it, we recollect it. Only missing aspect is we forget to reapply it. So we must do that in our life. And from reading these Tirukurals, I got an inspiration, asking myself this question: what is life? How do you define life according to you? In Hindu newspapers, in all the newspapers, when there is an obituary column, they will say DOB, DOD, in between there is a photo. DOB means date of birth, DOD means date of death. So the letter that has to date of birth has to travel to date of death. What is in between a letter? That is C. This is what our life is. So letter has to travel from B to D, in between only left out letter is C. That is what our life is. How life is very, very short for us. What is that C? C means see the entire world. How you will see? With compassion, with cheerful, with commitment, consistency. When there are challenges, you have to come out with, you have to conquer those challenges as opportunities. So see the world, commitment, consistency, conquer challenges. Ultimately what you get? Completeness in your life. That is very, very important, dear friends. So we have explained about how life is very, very short. So explaining everything, see the life aspect, DOD, DOB to DOD, how concise form. Likewise, PIL should also be in a very, very concise form, dear friends. So with this, let me quote one writ petition PIL very, very quickly, and then how it has been drafted. It is available in live law. I have downloaded from it. If possible, I will circulate in our group also. In this case, in the Supreme Court of India at New Delhi, civil original jurisdiction, very important aspect is for AOR aspirants. Under Order 38, Rule 12 Clause 1, Clause D, that means he files a direct PIL before the Supreme Court. This rule has to be prescribed by everyone when you draft a petition. Now let us see what is his destination, what is his prayer in this case. His prayer is, in the facts and circumstances of the present case, and in the interest of this justice, this Honorable Supreme Court may be pleased to A. Pass appropriate writ, order or direction in the nature of mandamus to the respondents for framing the specific procedure, rules and guidelines for what? For disposing of the mercy petitions within a time-bound manner. The petitioner, as a public-spirited person, he is knocking the doors of the court to deliver a guidelines, set a prescribed procedure, prescribe a time-bound manner by which the president or the governor can dispose of the mercy petitions. That is his first prayer. Second is, pass appropriate writ, order or direction in the nature of mandamus, directing the respondents to fix a time frame within which the mercy petition has to be decided. This is very important, dear friends. And the consequences of not disposing of the mercy petitions within such time frame. When a president takes 8 years, 10 years to dispose of the mercy petition, then what is the consequence? So that also please tell us. And pass any other further orders as deemed fit and necessary by this honorable court in the interest of justice. So we have seen what is his prayer. Ultimately, what is he asking before the Honorable Supreme Court is frame the guidelines with respect to the disposal of mercy petitions within a time bound manner. If it is not disposed within a time frame, what are the consequences would follow? Please explain us. Please give us the guidelines. Please lay down the law under Article 141 of the Constitution of India. This is what his prayer. Now let us see how his destination towards this prayer reached by facts and grounds. Name of the petitioner is unknown, dear friends. It is hidden. Versus Union of India, Ministry of Home Affairs. Because with respect to the mercy petition is, when mercy petition goes to the president, they refer the matter to the Home Ministry to check everything and then they will give the details. Number 2, the Ministry of Law and Justice. Now, whether in a writ petition, whether he has averred as per the requirement of Order 38, Rule 12, Clause 1 and 2 and 3 of rules. The petitioner herein an advocate by profession and is also a social activist. The petitioner is not involved in any pending, dear friends, whatever the rules that we have studied, he has put it in the first paragraph itself. Therefore, to avoid unnecessary defects to be pointed out by the registry. The petitioner is not involved in any pending civil, criminal or revenue litigation which has or could have a legal nexus with the issue involved in the present petition. Concerned authorities were not moved for the relief sought in the petition. He says concerned authorities were not moved. The petitioner has no personal interest in the issue involved in the present petition. Rights guaranteed under 14 and 21 of the Constitution of India are being violated of the convicts due to lack of framing of proper procedure, rules and guidelines in disposal of the mercy petitions of the convicts. When the mercy petitions are pending for so many years before the governor and the president, it violates Article 14 and 21 of the Constitution, because the death is always, he is not able to have his proper sleep when is the execution of the warrant comes. The petitioner has invoked the extraordinary writ jurisdiction of the Honorable Supreme Court of India and High Courts whenever the fundamental rights of the citizens of India are being violated or in danger of being violated, or if there is arbitrariness or discrimination in implementation and exercise of the powers by the state, or any power or function of the state or its authorities are unguided or unchannelized. He says when it is not properly, when there is no proper guidelines, then there may amount to partiality. They may dispose of the mercy petitions for one person yearly, immediately. For some persons it is delayed. So there will be arbitrariness, whims and fancies will be exercised by the state and the central government. Therefore, give us the proper guidelines. The petitioner by way of the present petition is invoking the extraordinary writ jurisdiction of this honorable court under 32 of the Constitution of India, seeking issuance of appropriate writ. He is repeating his prayer. Since there is no specified written procedure and guidelines for disposing of the mercy petitions within a time bound manner, the same is resulting in arbitrariness in disposal of mercy petitions. It also leads to undue delay in disposal of mercy petitions and thus giving rise to public unrest and creates doubts and suspicion in the mind of public at large. In quite a few cases, there is a prolonged delay in disposal of the mercy petitions, and in such cases, the convicts are able to take the benefit of the delay and get their death sentence converted into imprisonment for life. The victims and their families feel cheated, because the victim's family, they wanted the death sentence for the convict, but once it is delayed by the president and the governor, automatically death sentence is converted into life when they approach the Honorable Supreme Court. The real victim's family, they feel cheated. Why there is a delay and why there is a conversion from death sentence to life? So the victims and their families feel cheated in such cases. For effective disposal of the mercy petition in a time-bound manner and for transparency therein, it is must that specific procedure and guidelines for disposing the mercy petitions within a time-bound manner are immediately framed and implemented. He says 1A, he has given a clarification that the petitioner has not approached this honorable court seeking similar relief or any earlier occasions and has not approached the concerned authorities for similar relief. So he has fulfilled all the criteria. Who is he, what is his credentials, and everything he explains in the subsequent paragraphs also. So ultimately, dear friends, he explains how the mercy petitions takes the form when it is filed, where it goes, and which are the ministries, and he is asking under RTA also, was there any set of guidelines? The RTA, in RTA they have said we don't have any set of guidelines. The ministry has come out with a response that we have no guidelines with respect to the disposal of mercy petition. Then he had asked yet another question, is there any step being taken by the central or state government to come out with certain guidelines? The answer is no. So he files all those RTI and then he says, in the absence of grey area, please give us lay down the guidelines. So what is his grounds? Now let us move on to the grounds. So he has explained the facts and he has put up all the RTI informations as annexures. Now what are his grounds to reach the prayer? First ground is there is no specified written procedure and guidelines for disposing of the mercy petitions within a time-bound manner. The same is resulting in arbitrariness and discrimination in disposal of the mercy petitions. Number 2, because absence of specific procedure, rules and guidelines also leads to undue delay in disposal of the mercy petitions. C, because undue delay in disposal of the mercy petitions give rise to the public unrest and creates doubt and suspicion in the minds of public at large. Ground number D, because in quite a few cases there is a prolonged delay in disposal of the mercy petitions, and in such cases the convicts are able to take the benefit of the delay and to get their death sentences converted into imprisonment for life. E, because the victims and their families feel cheated in such cases where due to delay in disposal of the mercy petitions, the death sentence are converted into sentence for imprisonment. F, because for effective disposal of the mercy petition in a time-bound manner and for transparency therein, it is must that specific procedure, rules and guidelines for disposing the mercy petitions within a time-bound manner are immediately framed and implemented. So the grounds goes like this, dear friends. So first and foremost importance in drafting PIL is clarity in your mind. What is your prayer? Plain language. Yet another C is concise form, where we have derived the inspiration from Thirukural. Now ultimately, once there is a clarity in our mind that this is what our prayer is, then you can reach that prayer by narrating the facts of the case as well as the grounds under which you are seeking the relief, supported by documents. So this is how you have to draft a PIL petition is concerned. Now few seconds or few minutes, let me sum up, dear friends. We have nearly dealt this public interest litigation under 3 sessions. The first session was dealt with origin of PIL. Second session, that is lecture number 8, that dealt with avatar of PIL, how it has protected the prisoner's right, bonded laborers, victims at workplace, to prevent sexual harassment at workplace, how transgender are treated as third gender, environmental issues. So these were the different avatars of PIL. Today in the 9th session, we have dealt with again how the misuse and abuse of PIL, how public interest litigation has converted into publicity interest, private interest, political interest, paisa income interest. So therefore that should be curtailed, and a person, one who maintains a writ petition, not only approaches the court with clean hands, but also clean mind, clean heart and clean objectives. If it is not so, petition may be dismissed with heavy cost. And thereafter we have seen the procedure under Article 145 Clause 1, which empowers the Honorable Supreme Court to frame Supreme Court rules. Supreme Court rules under Order 38 Rule 12 deals with public interest litigation, in which an applicant who maintains the petition must state who is he, what are the credentials, what is the source of information, cause of injury, how it affects the public at large, whether he has any interest, political interest, personal interest, whether he approached the government authorities for any relief, if so, what is the relief. And we have seen how a petition is to be drafted by referring to a petition filed under Article 32, that is for public interest litigation. With the prayer, the Honorable Supreme Court is prayed to frame the guidelines to dispose of the mercy petition. If the mercy petition was not disposed in a time-bound manner, then what are the consequences? So these are all the broader line about PIL. I wish everyone to study this, make notes and keep repeating or reciting as if you are delivering a lecture. Therefore, it not only burdens, don't treat it as a burden. It is a pleasure reading it. It is going to be helpful for your, not only for your examination, but also for your practice. In my humble submission, dear friends, AOR is not something that it requires only 5 years experience to become eligible. Even after becoming an AOR, I became an AOR with utmost modesty, with utmost humbleness. I say, I completed AOR in the year 2014. We are in the year 2024. We need to update ourselves every day, every minute. This life has taken the existence in the year 1984. Everybody is born. Everybody is taking food from their beginning till the end. So likewise, the wealth of knowledge should be accumulated by every one of us. AOR is not an examination. AOR is a life journey, and we must understand that, because being a practitioner in the highest court of the land, we must have the maturity, we must have the accountability. We should approach the cases with utmost sincerity. With this, I thank you so much, dear friends. I am very much privileged and honored to share my thoughts with all of you. Thank you. Thank you so much.